and YouTube, and sign up for schedule alert emails at cspan.org.
More now on TSA's security procedures, including the constitutionality of body scanners. After that, a security expert talks about defending against terrorism with smart intelligence. And later, a look at the effectiveness of current security. This is 2 hours and 35 minutes.
For those who are watching us on C-SPAN or following the streaming video or the tweets, I just want to remind you that you can learn more information about this conference and this topic at epic.org/events/TSA. We also have a Twitter hashtag, which is #ScanTSA. As for our program, we will have one more panel this morning. There will be a break for lunch. There will be a keynote speech next by Bruce Schneier. And then our closing panel today will look at next steps for reform. And that's a particularly interesting panel. We will have on that panel New York City Council member David Greenfield, who has introduced a bill in the New York City Council to simply ban the airport body scanners in New York. We're also going to be joined by a staff member for Congressman Jason Chaffetz, which many of you know as the person who sponsored the legislation that passed the House in 2009 to prohibit the TSA from making body scanners the primary screening technique in U.S. airports. So though we have a brief break between 12:30 and 1:30, we'll be back afterward with a very good presentation by Bruce Schneier and then a closing panel. So if we could get underway, please, with our third panel. The bios are included in the speaker packet. They're available on the internet site. But it is a particular pleasure for me to be able to introduce our first speaker for this panel, Professor Jeffrey Rosen from the George Washington University School of Law. I think among all of the people who have written and talked about the significance of surveillance, the human body, and privacy, there's probably no person who's written as broadly and as thoughtfully, nor with as keen insight to what direction the law might take us than Professor Rosen. He is the legal columnist for the New Republic, a frequent contributor to the New York Times, did a piece, in fact, in the New York Times Magazine after he had spent some time in London looking at surveillance cameras there, several important books. But as I said, this ability to, on the one hand, understand the broad significance of these types of technologies, and at the same time think how the courts and even particular judges and justices might assess this within our legal framework, makes us all very fortunate to have with us today Jeffrey Rosen.
Thank you so much, Marc, for those extremely kind words. Much of what I've learned about the unconstitutionality of the body scanners has come from Marc and Epic's path-breaking briefs and work, and I'm delighted to spend a few minutes this morning evaluating the constitutional arguments for and against the body scanners. I have concluded, I was initially uncertain about this, but I've concluded, although it's not a knockdown case, there's a strong argument that the body scanners are violations of the Fourth Amendment, which protects the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. And the basic argument is that the body scanners needlessly invade privacy and also that they're ineffective. Aside from that, Mrs. Lincoln, they're great machines. But those two aspects of the body scanners, the fact that they could be designed in ways that protect privacy and that they don't work, make them constitutionally unreasonable. So as you've been discussing this morning, it's possible to design body scanners in ways that provide just as much security without invading privacy. And what's so remarkable about this is that the government knew this 8 years ago. That was the time when officials at Orlando International Airport first began testing the backscatter machines that are at the center of our current national uproar, and the designers of the scanners at the Pacific Northwest Laboratories offered the government a simple choice: blob machines or naked machines. Either you could have the backscatters designed to reveal images of the naked body, or you could scramble the images into a nondescript blob. Both were equally effective in identifying contraband. And it's remarkable that European authorities that evaluated this question all chose the blob machine rather than the naked machine. The handful of European airports that have adopted these technologies, such as Schiphol Airport in Amsterdam, recognize that given the fact that both machines are equally effective, any sane attempt to balance privacy and security would favor the blob machines over the naked machines. Now, it's true that most European airports have declined to adopt the body scanners at all because of concerns about their effectiveness. Why did the US government make a different choice? Faced with what seems like an easy choice, it made the wrong one. Well, part of the problem is that the US government has never been very good at protecting privacy. We lack effective privacy regulatory agencies, such as those in Europe, which were central in raising concerns about the backscatter machine. The Department of Homeland Security Privacy Office seriously fell down on the job in approving these machines without demanding the blob alternative, ignoring the warnings of people like Marc Rotenberg and Epic. And this was a needless controversy. All right, what is the relevance of the fact that you could have blob machines rather than naked machines for the constitutional analysis? The Supreme Court has not evaluated airport screening technology, but here's the broad framework. The Supreme Court has held that routine searches at the border and at airports, such as magnetic machines, regular X-ray machines, and also non-intrusive pat-downs, don't require any degree of individualized suspicion. But non-routine border searches, like body cavity searches and strip searches, do require a degree of individualized suspicion. So the basic question, which you don't have to be a lawyer to figure out, is, are these naked machines strip searches or not? If they are, then they require some degree of heightened suspicion. If they don't, then they don't require it. Now, there's a little bit of more doctrine that's filled in by the lower court opinions evaluating these machines. There's a Ninth Circuit ruling from 2007 which emphasizes that a particular airport security screening search is constitutionally reasonable provided that it's no more extensive nor intensive than necessary in light of current technology to detect the presence of weapons or explosives. That's a case called the Akai case. It's quoting an earlier California case from the 70s called Davis. And the idea there is that if you can design a technology in a less intrusive way, then it's presumptively unreasonable. And that opinion was reinforced by a 2006 opinion by the U.S. Court of Appeals for the Third Circuit, written by Samuel Alito, then a judge on the Third Circuit, now, of course, on the Supreme Court. And in this case, called Hartwell, Judge Alito stressed that screening procedures have to be both minimally intrusive and also effective. In other words, they have to be well-tailored to protect personal privacy, and they have to deliver on their promise of discovering serious threats. Alito upheld an airport check which involved walk-through magnetometers, and then if an alarm was set off, there was a secondary search with handheld wands, and he said that airport searches are reasonable if they escalate in invasiveness only after a lower level of screening discloses a reason to conduct a more probing search. So you could apply Alito's two tests, that the technology has to be minimally intrusive and it has to be effective, and say that these naked machines clearly fail both of these tests. They're not minimally intrusive because they could easily be designed in ways that protect privacy rather than threatening it. In other words, you could have the blob machines rather than the naked machines. And they're also not effective. The British member of Parliament who evaluated the machines for the British government said that they would not have found the chemical powders, the PETN powders that were carried by the Christmas trouser bomber the Christmas before last, and in that sense they don't even detect the low-density contraband that they're supposed to detect. So that's the core of the constitutional case against the body scanners. What is the case in favor of them? I think the case in favor of them would go something like the following. It would stress that the courts have never held that you have to adopt the least intrusive means possible, In the Hartwell case, Judge Alito had a footnote 10, that said in the airport screening context, there could be more intrusive methods than the magnetometer wand test that are reasonable. Judge Sotomayor in 2006, before she was a Supreme Court justice, in a case regarding random warrantless searches of ferry commuters, said what matters is not whether the defendant could have devised a less intrusive means of searching passengers, but whether the means they choose unconstitutionally trenched on the plaintiff's privacy interests in an unreasonable way. So those are two current Supreme Court justices who said you don't actually have to choose the least intrusive means, which could make the case more complicated. And then as to effectiveness, there are plenty of Supreme Court and lower court cases that emphasize that the court shouldn't second-guess law enforcement authorities when it comes to effectiveness. There's a Second Circuit subway case saying the plaintiff said that setting up random checkpoints in the subway wasn't effective in deterring terrorist attacks because you can just choose another subway station to go through, and the court rejects that, saying we will not and may not second-guess the minutiae of the NYPD's decisions, and basically they're going to defer on that score. So those are the strong arguments on the other side. You don't need the least intrusive means, and you don't have to prove that the technology is completely effective in order to work. I want to close by emphasizing the importance of judicial evaluation of these technologies in a way that translates the values of the framers of the Constitution in light of new technologies. This is a time when courts are divided about how to think about broad searches. We had just this week a case in California upholding the warrantless searches of cell phones on the grounds that when you're arrested, a cell phone is just like a cigarette packet which the cops are allowed to open. Other courts said that's preposterous. A cell phone which can contain all of our most private data, it's like a computer that includes our diaries, is much more like the papers that the framers were determined to protect and should require a warrant. And just a few months ago, there was a fascinating decision here in DC striking down GPS surveillance of cars without a warrant. Some other lower courts had said you can stick a GPS device on a car and track it door to door because we have no expectation of privacy in public. Judge Douglas Ginsburg, in a path-breaking opinion, rejected that wooden and unconvincing literalism and said there's a big difference between the fact that your neighbor could see you for a moment and take a snapshot of you and observing the totality of your movements 24/7, which transforms the nature of our conduct in public spaces. For me, this backscatters question is one of the central constitutional and civil liberties challenges of our age because it's so unnecessary to have the invasive machines. You could have privacy protecting machines, and it's so important for judges, rather than adopting the unconvincing argument that we surrender all expectations of privacy at the airport, have to realize that these virtual strip searches are just as much of an indignity and just as unnecessary as a real strip search, and for that reason, they are constitutionally unreasonable. Thank you so much.
Thank you, Jeff. Our next speaker is Ginger McCall. Ginger's Counsel with the Electronic Privacy Information Center, EPIC. She's Associate Director of our Open Government Project and has become one of the lead attorneys in the case EPIC versus DHS to suspend the body scanner program. I should mention also that she was the attorney who led the litigation in the open government litigation against the DHS regarding the technical specifications and design of the devices. So maybe she'll tell us a bit as well about the open government cases.
So as Marc mentioned, we actually have several cases against DHS, and our current case to suspend the program is actually based on documents that we got as part of another case, another EPIC v. DHS lawsuit. That lawsuit was grounded in a Freedom of Information Act request that we made to the Department of Homeland Security, and they repeatedly ignored. And we eventually filed suit over that. You're going to start to see a pattern here as I'm talking to you, that the agency repeatedly ignores our requests, and they try to do everything that they can really to obstruct our efforts to get any answers about these machines. So we ended up filing suit against the agency in this case, and as a result of that lawsuit, we finally got some documents out of them. When we looked at these documents, we found several very, very interesting and important facts. First, we found that these documents showed that these devices were required by TSA in its procurement specifications document to be able to store and transmit the images captured by the devices. So that graphic naked image is actually capable of being stored and transferred, and that was because TSA required that the manufacturers make the machines capable of that. The documents also showed the extent of traveler ire at these machines. One of the document sets that we requested was traveler complaints, and we got hundreds and hundreds of pages of traveler complaints. What you would expect, people being very upset about their children being patted down, concerns by pregnant women about radiation. There were a number of people who cited the health risks of the machines. And then there was sort of a general pattern of complaints that we saw, travelers not being informed of the fact that they could opt out, they could opt for the pat-down, not being informed of what the machines were before they had walked through them, not being informed about the capabilities of these machines. Basically, TSA was not putting up proper signage in the airports. The documents also showed that these body scanners were not designed to detect powdered explosives. Contrary to what TSA says, they're not effective, in fact, at detecting the very explosives that they're supposed to detect. And the documents also showed that privacy filters could be turned off. So we had also previously filed 2 petitions to the agency to ask for formal rulemaking, a notice and comment that would allow the public to participate in the agency's decision to deploy these machines that were costing millions and millions of dollars to the public and that people were being subjected to before they could travel. Again, the agency was obstructive. They ignored our petitions. They refused to either deny our request or accept it. They just simply failed to recognize our petitions as petitions at all. So with this in mind, we decided that we were going to file suit to suspend the program on the basis that the body scanners are invasive, unlawful, and ineffective. Our lawsuit was based on several federal statutes and the Fourth Amendment of the U.S. Constitution. We based this on the Administrative Procedures Act, the Privacy Act, the Video Voyeurism Prevention Act, the Religious Freedom Restoration Act, and the Fourth Amendment. So for our claim under the Administrative Procedures Act, our claim was based on the fact that the agency failed to properly process our petitions, despite the fact that our petitions stated outright that what we were asking for was a rulemaking. The agency simply never acknowledged that. They didn't deny, they didn't accept. They simply sent us back nice letters, which were basically a copy and paste of their press releases, of their website, about what these machines are capable of. They failed to even acknowledge that we had asked for a rulemaking. And under the Administrative Procedures Act, this is in fact a rule, and it is subject to rulemaking, and there should be an opportunity for public comment. And again, this is just part of the pattern of obstructive behavior on the part of the agency. TSA apparently feels that it doesn't have to answer to the American public for the money that it spends, the decisions that it makes, and the rights that it violates. So our next claim was the Privacy Act claim. This technology allows for the linking of names and personally identifiable information with the graphic naked images. That was what our claim was based on. And because of that, this would trigger a system of records notice that would be required by the Privacy Act. And TSA failed to undergo that system of records notice. Our next claim was under the Video Voyeurism Prevention Act. This prohibits the capture of an image of a private area of an individual without their consent. And we found this claim was really buttressed by the complaints that we saw. People were not being informed by TSA what these machines were, what the machines were capable of. TSA had been misrepresenting to the American public about the capabilities of these machines, saying that the machines can't store and transfer images when in fact they can. These machines capture a very graphic image, including the genitals of American travelers, and project that image onto a screen for a TSA officer to look at. That image can then be stored and transferred by these machines. Our next claim was under the Religious Freedom Restoration Act, and I'm actually going to leave this one to Nadhira because she's probably the best person to speak to this. And our last claim was the Fourth Amendment claim, which I think Professor Rosen did an excellent job of covering. I'm just going to add a few small things from our brief. So our argument on this, one of the arguments that we made that we feel is very compelling, is the fact that under the case law, the agency, while they are granted a wide amount of latitude in airport searches because of the necessity of national security, there is the requirement that the agency not start with the most invasive of all methods. There has to be some sort of escalation of methods. You start with a less invasive method, and then when you're given a reason to escalate, then you can escalate up to a more invasive method. You wouldn't start off with just a basic strip search and full body cavity search. You would start off with a magnetometer. And this is what the case law mandates, but in this instance, with these very, very invasive body imaging machines, what they're starting off with is the highly invasive tactic instead of the less invasive tactic of magnetometers. So this is really based on the fact that they've decided to deploy this as primary screening, and that primary screening sets up this very invasive tactic as the very first thing that is used on American travelers. So since the submission of our initial brief in November, TSA has repeatedly tried to delay our lawsuit, which was really, I think, no surprise to us. But we actually are filing our reply brief in this lawsuit today. That brief can be found on our website, as well as all of the other documents that I've mentioned, the procurement specifications document, operational requirements that we got as part of our Freedom of Information Act lawsuit, our initial brief, the agency's response, and the brief that we're filing today. Thank you.
I'm very pleased to welcome our next speaker, Nadhira al-Khalili. She is the legal counsel for the Council for American-Islamic Relations. We've worked with CAIR in the pursuit of this case, and Nadhira herself is one of the attorneys and also one of the petitioners involved with the case. Nice to have you here.
Thank you very much, Mark, and thanks to EPIC, and thanks to all of you all who are here today for this very important conference. I appreciate you all coming out today. As Mark mentioned, my name is Nadhira al-Khalili. I'm an attorney at CAIR, the Council on American-Islamic Relations. And CAIR is an organization that was started in 1994. And we're a grassroots civil rights organization. We have approximately 30 chapters across the United States and about 20 states. And our mission is to enhance the understanding of Islam. And we don't claim to represent all the approximately 7 million Muslims in the United States of America, but we hope to at least represent the majority of the moderate mainstream Muslims in the United States. When I started working at CAIR, we would slowly get in constituent complaints about this machine that I went through. I went through this machine, I don't know what it is, or I was told what it is, and I wasn't told that I had an alternative to go through it. So we slowly started to research what the machine was and found out that it was very problematic and downright unconstitutional and unlawful. And we hooked up with EPIC, which was really a great opportunity for us. And as Ginger mentioned, we currently have a case in the DC Court of Appeals where we're asking TSA to suspend the AIT program. I'm a petitioner on the lawsuit under the federal statute called the Religious Freedom Restoration Act. And as a petitioner, it is my contention that as a Muslim, as a member of the Islamic faith, that I am being kept from practicing my faith. Now, I understand that there was an earlier panelist that said that all terrorists are Muslims. Clearly, we don't agree with that, and I feel like I should have the right to practice my faith when I'm going through the airport. And so, as you can notice, I'm dressed from head to toe, and I'm dressed from head to toe every day of my life. And I feel that if I go through the body scanner, that violates my modesty rights in my religion to not be seen unclothed. And so, it's my argument that because this particular program is not the least restrictive means for the government to advance a compelling interest, then it infringes upon my right to practice my religion. Now, I would also like to state that obviously other people have objections to this, people of other faiths who have modesty concerns within their faith, and of course people that have no faith who still have modesty concerns. But you know, this is just one of the several ways that we tried to get the program stopped, and you know, just one of the arrows in our quiver, so hopefully it will work. Currently, the government is arguing that I don't have standing and that it's, what's the word? What are they saying? Don't have standing, and the claim is baseless. Those are their arguments. On March 10th is the oral argument for the case, so hopefully you guys can all turn out for that. So that's a little bit about the invasiveness and the unlawfulness of the AIT's program. But Other people have talked about the ineffectiveness, and I don't necessarily, I'm not, a security expert, and I don't necessarily want to talk about the ineffectiveness, but I'm happy to be here to represent the perspective of someone who's coming from a faith community. Now, I believe that I am a civil rights advocate who just happens to be a member of a faith community, and as a civil rights advocate, I think we should look at the bigger picture, which is what we're doing here in this conference. Look at the moral issues of this program, and the ethical issues, and the health, and the safety, and the privacy issues. And just, really think about how shocking this is to be such an affront to our civil rights. And it was alluded to earlier, but my question is, what's next for the government? What other things is our government thinking about right now that we don't know about that they're going to roll out and surprise us with? So I'm looking forward to the last panel, which is talking about turning points and different suggestions and what to do next, because I think this is part of a bigger issue where the United States is being turned into a police state, and we are, the people, we are the people, and we're the ones that should be objecting to it. And so I hope we can have a very lively discussion later this afternoon about next steps and goals and programs and different ways to combat this, both legally, grassroots, everything, so that once we deal with this issue, we're prepared to deal with the next issue that we know is coming down the pike. Thank you very much.
Okay, I'm going to introduce now our final panelists and mention that one of the wonderful things about organizing this event as we began to try to identify people and topics is that we realized that there were so many people out there for different reasons who shared our concerns about the use of body scanners. And I think you see that in particular with regard to the legal arguments, the challenges that are being brought to the body scanner program. But we were also very interested to learn that there were 2 Harvard Law School students who apparently had a lot of free time and have in their own right brought an important case to challenge the airport body scanner program. So I'm very happy to welcome Jeffrey Redfern and Anant Pradhan, who are going to speak with us about their case, Redfern versus Napolitano.
Thanks to EPIC for inviting us here. We're really excited to hear from all these people and share some of our experience. So what makes a second-year law student file a lawsuit against the United States government? Well, I consider myself a little L libertarian, so I'm outraged at the government on a pretty daily basis. But what was remarkable about this case was that as I started looking into the case law, I found that the justifications for these searches were really quite shaky. Now, there's been a lot of case law on so-called administrative searches. These are searches that everyone has to go through regardless of whether there's probable cause or reasonable suspicion. And the courts have come up with a basic balancing framework where on the one side we're going to look at how intrusive is this search. On the other side we're going to look at what is the government need that's being served and how effective is it. Now, what's different about this case from almost all of these other administrative search cases is that in the other cases, the courts have always held that the intrusion is minimal. So it's not that hard then to do the balancing test. We have something really light over here. We've got planes blowing up. Okay, I think we're going to let this go. And the DOJ is trying to say that this is just one incremental little step. That because we're forced to walk through a metal detector, that it stands to reason that we should be forced to walk through these strip search machines. But the Supreme Court has made it clear that this is a very different situation. Just 2 terms ago, there's a school strip search case that some of you may be familiar with. Sorry, I'm missing my quote here. Justice Souter, writing for the court, said that there's a quantum leap from outer clothes and backpacks to exposure of intimate parts. The meaning of such a search and the degradation its subject may reasonably feel place a search that intrusive in a category of its own, demanding its own specific suspicions. So this is really unprecedented. Really, the only administrative searches that have gone this far are in prisons. Outside of prisons, this is as far as they've ever tried to push it. Now, how do you weigh something heavy on one side and something heavy on the other side, though? These balancing tests that judges try to implement, normally they try to say, okay, we actually have something light here, and it's easy. When you're looking at something weighty on both sides, our position, in our case, is going to be that you need to have more scrutiny on both sides. So I don't think it's real tough to say that this is very intrusive. But our argument is that because it's so intrusive, that the normal deference to law enforcement, to the executive's interest in national security has to be lessened. The only way we can do this balancing is if the courts are going to actually look at the evidence and assess whether or not this is effective. Otherwise, the courts have really abdicated their judicial responsibility to enforce constitutional limits of government. Now, the Fourth Amendment, the language of the Fourth Amendment is not technical. It protects us from unreasonable searches. And once you get past the lawyerly language of three-prong tests and circuit splits, a reasonableness standard is anchored in our everyday experience and common sense. The Supreme Court has said that public opposition can be evidence of unreasonableness. And I think this means that we all have a duty to express our outrage, because this is going to help all of these suits go forward. If we just shut up and let it go and figure that, this is just one more thing, it's too much for me to worry about, then it's a lot easier for a court or a judge to say, you know what, I don't think this is that unreasonable because people aren't complaining that much. So I think that's something that we can all do to help keep these cases moving forward. My co-counsel, co-plaintiff, I guess, is going to talk about another sort of troubling issue in this case regarding jurisdiction. Thank you.
Thanks, Jeff. So basically, we are in a different position than, I guess, Epic is, in that we filed our case in trial court in federal district court, and they're now in the appellate court. This makes a substantial, there's a big difference here in that in trial court, there's a whole procedure of getting witnesses, getting discovery, getting information from them without necessarily needing Freedom of Information Act requests. And so for a number of reasons, we're trying to stay in trial court. Now, there's this little statute that we didn't know about before we filed the case, which is actually presenting quite the problem. It's 49 U.S.C. 46110. Go home and look this up. It's actually really a huge pain, and especially the way it's been applied. Basically, what this statute says is that final orders issued by the TSA must be reviewed by a court of appeals. But it goes further in that the C prong of it requires that findings of fact by the administrator, if supported by substantial evidence, are conclusive. So the reason this is problematic is that any order that the administrator were to issue would then be reviewed by the Court of Appeals, and as long as an administration could marshal a record, which I hope any reasonable or any competent administration could do, a substantial record, then those findings are conclusive. So what we're trying to do is essentially avoid this for a number of reasons. The key being that no one here actually ever knew that there was an order issued. It kind of happened in this backdoor secret sort of way. Basically what TSA does is that they issue secret service, SSDs, I believe, which I've colloquially called them super secret directives. Basically, behind closed doors, they issue these orders that say you have to do X, Y, and Z. This is how the procedure is going to go. But it varies from airport to airport, mechanism to mechanism, what they do, who gets screened, who doesn't get screened, how various things change based on various different circumstances. Now, the question is, how can these be final orders that can only be reviewed if, A, we don't know when they're issued, and B, we don't know what they say? So our contention is that they can't actually be final orders, and thus we don't need to go to the Court of Appeals to have this heard. The other very important thing is that in that statute, final orders must be reviewed within 60 days. But if you don't have a time, if you don't know when the order is issued, how do you file a petition within 60 days? It's kind of this black box. So basically, the TSA statute allows them to set the rules, choose the forum for reviewing the rules, and then have those rules reviewed based on whatever they want to say, and then it's deemed conclusive. For those reasons, we believe these super secret directives can't possibly be final orders, and that's the significant problem and hurdle that we're facing right now and trying to avoid.
Great, thank you. I'm afraid to admit I've actually spent quite a bit of time with that section 46610C, and it is, as you say, a problem. I wanted to begin by coming back to Professor Jeffrey Rosen, who's now heard from the various petitioners about the claims, and wondering if you have any initial response, and then I'll have a follow-up for you.
My first response is how proud I am to be sitting on a podium with people who are doing this sort of civil liberties work. What a wonderful thing it is that you second-year law students are defending constitutional values in the most direct way possible, and your vivid account of use the word moral issues, ethical issues that are really at stake here, the dignitary issues, gets to the heart of the matter. And Ginger's explanation not only of the constitutional problems with these machines, but also the statutory ones, is very persuasive. I'm supposed to play, well, what can I say? Is the Supreme Court going to buy these arguments? Predictions are hard. I think it was good to quote Justice Souter's language in the strip search case. That was an 8-1 decision. Only Justice Thomas dissented. 8 members of the court understood the dangers of strip searches. I think if I had, the 10 seconds at the beginning of an oral argument that the Solicitor General has to try to persuade the court, I would say this. Ladies and gentlemen, the court has held that a quintessentially reasonable search is one that only reveals dangerous and guilty contraband and no innocent but embarrassing information. A dog sniff, for example, which reveals drugs but no diaries. A backscatter machine is the antithesis of an unreasonable search. It reveals a great deal of innocent but embarrassing information and is very unlikely to reveal contraband or guilty information. That's the core of the case of reasonableness. Now, will the court buy it? Who knows? Unlike our heroic Harvard students who are urging the court to actually look at empirical evidence, like public opinion or polls, the court tends to decide these Fourth Amendment cases just with armchair generalizations that are unsupported by any empirical evidence. There's a wonderful study by Christopher Slobogin at Vanderbilt who found that the court's predictions of what people perceive to be unreasonable bear no relation to the actual intuitions of people and students in focus groups. Now, there's another great danger here, which is that the longer that these machines remain up and running, the greater possibility there is that the court will find that expectations of privacy have adjusted to them. Justice Scalia said in the Kylo thermal imaging case from a few years ago that cutting-edge technology that's not in general use is presumptively unreasonable if it reveals intimate details in the home without a warrant. But given the jurisdictional challenges that you face, by the time a court of appeals rules on this and the Supreme Court actually heard it, it might be 2 or 3 years down the line. By that point, people will have gotten used to it, and the court might have said that as a result they become constitutionally unreasonable. So time is of the essence. It's so important these suits move forward. I wouldn't confidently predict that the court will buy it, but I think that all of our colleagues here have made a very strong case that these are, in fact, constitutionally unreasonable searches.
Great. So, Ginger, we now have Jeff and Anant who have filed their lawsuit, and you've been at this for some time, both in building the record through the Freedom of Information Act litigation, looking fairly closely at the legal theories. What would be your advice to them? Which arguments do you think they should pursue? And by the way, since they are in district court and have the opportunity to maybe do some discovery, what would you like them to find that you haven't been able to obtain?
I'd like them to be able to find the very sorts of testing that we've been asking the agency to undergo. The health testing, the testing for whether or not these are actually effective against powdered explosives, and we certainly have indications that they're not. The agency continues to insist that they're effective machines. I'd like to see the results of the testing for that. As far as experts go, probably to call in security experts who could actually speak to that effectiveness, who could actually speak to the radiation experts, who could actually speak to the radiation risks. I think all of that would be excellent to bring in.
Great, and I see you guys are taking notes, which is excellent. Nadhira, you've raised some very important and I guess at the same time troubling concerns from the faith-based community about the impact of these new screening procedures. And I was up late last night working on that brief that Ginger mentioned, and the government said in its answer to our brief, well, of course, people don't have the right to fly. So this is, in their assessment, really not a big deal. But I was wondering if you could actually say a little bit more about what the impact is on people who have faith-based objections, and what the practical consequences are when the government undertakes this kind of new procedure.
Thank you for working on that brief, by the way. The practical consequences are, I would say about 60% of Muslims that live in America are from immigrant communities who still have contacts with homes and family members and ancestors and ancestral homes in other countries, which are virtually impossible to get to unless you're flying. So the fact that TSA says, well, people don't have to fly, well, some people do have to fly. And we do recommend that people, right now, because there is no other alternative, that people go ahead and opt for the pat-down, because that's at least done through someone of the same gender. But the fact that this has really infringed upon people's right and ability to fly is very disturbing in the Muslim community, and we hope that we can get this taken care of as soon as possible.
I was thinking that even Mike Roberts, who objects to the current screening procedures, if he were invited to speak at a conference in, let's say, London or Brussels, would probably not be driving his car to go to that event. Let me come back to Jeff, though, because I actually want to push him a little bit on what the Supreme Court might do. He's been a great observer of the Supreme Court and helped us to understand, first of all, Justice O'Connor's role as a swing vote, and maybe now Justice Kennedy's role as a swing vote. But on these privacy issues, Justice Alito is emerging as a very interesting jurist on the court. You mentioned his opinion in the earlier airport case, the Hartwell case, and we know that Justice O'Connor herself was deeply suspicious of suspicionless searches. And I'm just wondering a little bit what your sense is, if we probe a bit more deeply about what the current court has said about similar issues, where they may come out if they actually do get this case.
It's hard to predict. After I, Marc, with your encouragement, hopefully predicted in a op-ed that Alito might in fact inherit O'Connor's mantle as the defender of Fourth Amendment values. Several students and colleagues and friends wrote in and said, this is wishful thinking. Alito has voted in favor of the government more frequently than any other justice in criminal cases. He's a former prosecutor. He's the most pro-prosecution justice. So there's an argument that he's by no means has O'Connor's libertarian instincts. The other difficulty is this is a court that's closely divided in Fourth Amendment cases and tends to side against the Fourth Amendment claims. This is in part not only because of the replacement of Alito with O'Connor, but also because Justice Breyer, for all of his many virtues, is no fan of striking down unreasonable searches. He tends to favor the government. He bends over backward to applaud searches, and he's by no means a sure vote here either. A case that might be relevant is the Bond case from a few years ago involving the inspection of luggage on a bus. And a majority of the court, I think it was a closely divided decision, the decision was written by Rehnquist, of all people, who was also more of a states' rights Fourth Amendment guy, said, people on buses expect to have their luggage touched or brushed by accident, but not lovingly and intrusively fondled. That basically that is too much, and when you travel, you shouldn't have to have your bags fondled. And Breyer, who I think rides the shuttle a lot, said, this is silly, all of us have our bags fondled, just get used to it, and he didn't have any problem with the issue. So I say, who is the O'Connor of this court? We're not even sure what Justice Sotomayor would do. That lower court opinion that I quoted from was one where she had upheld broad searches. She was also has a lot of pro-government experience, and her Fourth Amendment views haven't been revealed either. The strip search case, there was a gender element, and also, I guess, if I were to say when do Fourth Amendment values tend to win before the court, it's when judges can imagine their own privacy being violated. So the one case where, all drug tests in schools were fine, they were okay in all sorts of contexts, but when judicial candidates were drug tested, the court was shocked, and struck it down. All this is to say we can only hope that the Supreme Court is doing a lot of traveling over the next couple weeks and months, and that they're going to go to plenty of junkets and experience firsthand the indignity of being searched, because that's their best hope for actually striking these things down.
Maybe we should invite them to foreign conferences. Okay, wonderful. So we have some time for questions. If the people who do have questions, we'll get the mic circulating, and also people who are following us on Twitter, you're welcome to tweet some questions. We can ask them of our panelists. Yes, please.
Judy Greengold from the Puppet Treehouse, and I'm very curious to know, there are a lot of advocacy center around privacy rights. Of course, a lot of the issues that you're speaking about include privacy issues. I'm very concerned with the public health effects, obviously, of these untested machines, which have already generated a lot of outrage in the scientific community, supporting the dangerous effects of the radiation. And my curiosity is, what would the legal implications of these public health risks, say in 5 years, there's demonstrable evidence of a public health effect? Would there be, potential suit to be brought against the U.S. government? And of course, wouldn't the cost of that, not only in the public health interest, but the cost to the taxpayers, eventually mean?
Do you want to take that?
I can't really speak to it from a plaintiff's law perspective, but I think it would certainly cut against any argument on the government's part that these are reasonable searches. It would certainly cut toward the interest in privacy, cut against the public interest that they would be asserting. So I think that's probably the most that I can say on that.
I'm just looking at some of the factors that courts have evaluated in deciding whether the government discretion is reasonable. It includes the public nature of the search, the length of the search, notice given to the passengers, only visual inspection, and whether the search is abusive or unusually intrusive. And I think, although it doesn't directly cover the health effects, you could certainly argue that a search that has dangerous health effects is intrusive, abusive, not minimally invasive. And for example, a strip search or body cavity search that caused physical harm would surely be even more unconstitutional than a strip search that didn't cause physical harm. And for that reason, I think it would very much support the idea that these are not minimally intrusive searches.
It would certainly cut against any sort of assertion of a legitimate public interest. If your public interest is to protect the public and protect the safety of the traveling public, and then the machine that you're using to do that is creating a safety problem for the traveling public, it's going to be a very hard argument to make.
Regulate and test these machines, which can have potentially the long-lasting, generations-long effects. So wouldn't, this was something from the first panel, obviously, the question about why isn't the FDA taking any accountability? Why haven't these machines been passed through rigorous inspection if they are exposing the public to these risks? So to me, it would seem to open up a very wide legal, ramification for any sort of legal action on the part of people's wellness, either in the psychological. Basically, we're being forced to compromise between the psychological wellness with the pat-down and the sexual wellness, particularly for sexual assault survivors, or the actual physical health aspect of people going through these machines. So I'd be very curious to know what the legal next steps would be.
I can actually say a little bit more about this. We did not raise, other than in passing in our opening brief, the health objections, largely because we didn't feel that we had the expertise. But to the extent that we did raise them, the government attempted to answer our brief by saying that they had contacted a variety of organizations and basically been given, gold stars by those organizations in terms of the use of the technology. So this actually created an opportunity for us to reply, which we did. We pointed out, first of all, that the government had relied on studies not based on the operational use of the devices. And one of the points that scientists and engineers and others have made is that you can't evaluate, if I may say here at this conference, you can't evaluate the safety of a car without actually looking at its history and its record to understand whether or not it's well designed, to carry a family for 50,000 miles or something. But the second point that we made regards the way that the Administrative Procedures Act is supposed to work. In other words, a federal agency may have a view, it may have reached a judgment about what it believes is the best way to, address this problem, but under the APA it has an obligation to give the public the opportunity to offer its views, its contradictory evidence, and then to look at all of this information and to make a judgment that's reviewable by a court. Now, you see what happened here is that the Department of Homeland Security basically short-circuited that process. They didn't want contradictory evidence. They simply wanted to be able to place before the public their assessment and leave it at that. So one of the themes I think you're hearing today is that not only are there strong substantive objections, such as the Fourth Amendment and religious objections and so forth, but there are also very significant procedural concerns about how this decision was made. And this is significant because wherever you may come down on the substantive objections, maybe you agree with the religious arguments, maybe you don't, maybe you're not so concerned about privacy, I still think you have to believe that the government agencies making these decisions do so in a fair and lawful manner. And so a big part of our case is actually the claim that that didn't happen here. So that's a long answer, but I think that's how we get to your issue.
And I can also speak to it a little bit in the sense that we do file a claim about the health effects, and this is why being in a district court means so much more, in that we can have, if we get to stay in district court, we get to marshal the witnesses and have that debate about the health effects of these scanners. What we've gotten in what we've seen in some of the briefs is that they really just say that they've got studies from the American Medical Association and the FDA that just, as Marc was stating, that just give you the check mark. It's good to go. But we don't actually get to see those studies, and none of those studies are public information. So we have to take them at their word. Now, the benefit of being in a trial court is that we get to contest that a lot. More so than just having affidavits, and we've been contacted by some scientists who actually would like to state that it one way or the other as is out in the media.
And those tests that the government continues to cite, these are tests that were undertaken not necessarily to determine the safety of these machines and their effects, their possible effects on human beings, but to determine the output of radiation from the machines in a test setting, again, as Marc said, not the operational setting. And there are also, if the agency is going to be using machines that are dosing people with radiation, they need to really ensure that these machines are properly maintained. We've seen in hospitals there are machines that are dosing people with far higher doses of radiation than they're supposed to be because they're not properly maintained. The machines, there's no evidence that the government has taken the proper precautions to ensure that these machines are properly maintained.
I think we have another question in the back.
Yes, hello. This is to anyone on the panel. We're all talking about the safety from the machines, Well, what about the fact at the airport, I don't know if any of you have ever tried when you're flying to ask the TSA agent to change their gloves when they've checked you, because they were actually physically contacting one person's body and then taking those same gloves that have who knows what on them and physically touching your own, let alone the fact that TSA agents are wiping their eyes with them, picking their noses, rubbing their hairs, wiping your face with them. And I've never heard anyone sort of mention about this problem, because if one person has a disease, it can be transferred by the gloves. And at the airport, I've seen people ask, and the TSA basically threaten you and tell you no, and use the same glove that they just groped someone with on your private parts. I mean, has there been any study into this, or anyone speaking up about this part? Because some of them use the same glove for hundreds of people at the same airport. They don't change them. They have no need to. No one's going to make them, because they aren't listening to us asking politely to change them.
It's an interesting point. Has anyone picked up this?
I can speak from experience, because I've been patted down a number of times now. Part of they actually, I'm pretty sure, my understanding is that they do have to switch the gloves, and the reason being because after they pat you down, they actually do a chemical scan of their gloves. And so part of the test is to make sure that you don't have chemicals on you after they've patted you down. So if they weren't to switch the gloves every time, then you would get chemical residue from, say, somebody else. So I can't be sure. It might be a one-off, or it might be that they're not following procedure, but their procedures, I mean, again, it's super secret, so we can't actually be sure, would seem to indicate that they have to switch the gloves out.
They have to switch the gloves, but if you go stand in an airport and you watch, your chance of actually seeing them do that from one person to the next is pretty darn slim. I mean, you can just go pick an airport here and stand and watch this all day and watch them never change gloves, because we've seen it.
You know, this question of the gloves and the secondary pat-down might be relevant to an aspect of the constitutional analysis we haven't discussed. Should the courts evaluate the body scatter and the intrusive pat-down together, or should they be two separate procedures? My instinct is it's the same procedure, because if you choose not to go through the body scatter, then you have to do the pat-down. And the argument would be that the pat-down is just as intrusive as a strip search. It's not quite a body cavity search, but it's certainly not a routine search, and therefore it should be considered constitutionally unreasonable to offer as an alternative to a virtual strip search something that comes close to a virtual body cavity search. The counter-argument would be that you don't have to go through you don't have to fly, and you should just evaluate the body scatters in isolation, and the secondary pat-down shouldn't be part of the analysis. Marc, we haven't talked about that, but what do you think?
That's a really good question, Jeff. I'm going to have to think about it. I'm not sure at this point, actually. But what I wanted to do, though, at this point, because we have just a couple of minutes, and you, I thought, had made a very good point earlier, what the best opening statement might be for the petitioners, the attorneys pursuing these challenges, and maybe give each of our attorneys on the panel just a brief opportunity to say what they think the most compelling argument is, the most compelling legal argument to suspend the airport body scanner program. How would you answer that?
Oh, you're going to start with me?
Yeah.
I need a minute to think about that.
Nadhira, would you like to take that?
They're all so very compelling. I can't pick one, but of course I would argue for the Religious Freedom Restoration Act. I think it's very compelling, and I think because there are so many Americans that have sincerely held religious beliefs, that if nothing else, that our government listens to that argument and really takes into account that this country has such a strong faith in different faiths, and it should, if they can do something less intrusive, they should go with that, so that people will have their religious freedoms.
And actually, one of the things I've learned about that law, which is so interesting, is that even where the government establishes a compelling interest, it still has a burden to show that it's pursued the least restrictive alternative. It's not just a tie goes to the runner situation. I think they have some work to do on this.
Absolutely.
Yes.
I'm ready now.
Okay, good.
I think really the most compelling argument against them is that by placing these machines in airports, what the TSA is doing is requiring that people trade away their privacy for the illusion of security. you are not getting security with these machines. They are ineffective. The machines are highly invasive, though, so they're taking a high amount of your privacy. So I think that that's...
Well, we're pretty focused on the motion to dismiss at this moment, so I think for getting past that stage, I think the first argument is going to be that this is the most invasive administrative search ever conducted outside of a prison. And I think that alone should make it pretty clear that you can't kick this out at the pleading stage, and we need more analysis and more evidence.
Great. What do you think, Jeff? We got a chance?
If I had a closing statement, I would obviously end by quoting our mutual hero, Justice Louis Brandeis, who was the greatest prophet of the necessity of translating constitutional values in light of new technology. Brandeis recognized in the age of the wires that wiretaps were unreasonable because although they didn't involve physical trespass, they were far more intrusive than the paper searches of desk drawers and diaries that the framers of the Fourth Amendment were determined to prohibit. We have to try to convince courts today and ultimately the Supreme Court that a virtual strip search is even more of an indignity than those general warrants and diary searches. The framers would have been appalled at the idea that hundreds of millions of travelers, in order to get through the airports, could be visually and virtually stripped naked, and they must strike down these naked body machines as a violation of the quintessential right, as Brandeis called it, the right to be let alone.
Oh boy, that was great. Thank you all so much for a wonderful panel. We will break for lunch and be back in this room at 1:30.
To have a conversation over lunch, and we're going to start the second half of the